Imagine committing a really serious crime. Like, the police slap the cuffs on, you're sitting there in a jail cell waiting for your trial, and then you just walk completely free.
Right, which sounds totally crazy.
Yeah. Not because you hired some, brilliant lawyer who found a loophole or anything, and not because the evidence mysteriously disappeared, but because the law you actually broke simply vanished into thin air.
It honestly sounds like a glitch in the Matrix.
Yeah.
But it is a very real, very fundamental part of how our legal systems actually operate.
Which is wild to think about.
It is, because we tend to treat laws as these permanent, immovable structures, like stone monuments or something. But the reality is that the law is a highly reactive, constantly mutating organism.
And that mutation process is exactly what we are exploring today. We are taking a deep dive into the hidden mechanics of how laws actually function behind the scenes.
Right, the stuff they don't usually show you on those legal TV dramas.
Exactly. We're looking at a really fascinating legal textbook excerpt today, specifically Unit 5, which covers the impact of amendments and repeal.
It's a great source.
It really is. We'll be decoding how laws change over time, the chaotic ways they die, and the turf wars that break out when two laws try to govern the exact same space. So, okay, let's unpack this, starting with how laws evolve to survive.
Because before a law faces total annihilation, it usually gets tweaked.
Right. And the source makes a massive distinction between the two ways that happens, right? Substantive amendments versus procedural amendments.
Yeah, and that distinction is everything. It dictates exactly how your everyday life is affected. Yeah. So a substantive amendment goes straight to the core of your rights, your duties, and, your liabilities.
The actual meat of the law.
Exactly. It creates something totally new or destroys something old in the substance of the text. A procedural amendment, on the other hand, leaves your fundamental rights entirely alone. It merely alters the machinery.
Like the administrative steps.
Right, the steps you have to take to enforce those existing rights.
I always think of this like a smartphone software update.
Oh, that's a good way to look at it.
Yeah, so a substantive amendment means you wake up and your phone has a totally new app feature. Let's say you suddenly have the ability to, edit a text message after you send it. You have a brand new capability.
Right, a totally new right.
Exactly. But a procedural amendment is just an interface update. You have the exact same apps, the same capabilities, but now you have to, swipe left and dig through a new submenu to find them.
That analogy maps perfectly onto real legislative actions. Consider the 2013 Companies Act in India.
Oh, right, the CSR rule.
Yeah, Parliament passed a substantive amendment there that forced certain profitable companies to start spending a mandatory percentage of their net profits on corporate social responsibility activities.
Which is a huge deal for a business.
Massive. They essentially dropped a brand new financial obligation onto corporate boards that fundamentally alters the core duties of a business. It's a new feature, like your app analogy.
Versus just changing the menus. The civil courts give us a great example of that one.
The mediation amendment.
Yeah, there is this major procedural amendment to the Civil Procedure Code. It made alternative dispute resolution, so things like mediation or arbitration, a mandatory first step before you could file certain types of civil lawsuits.
And notice how that doesn't strip away your fundamental right to sue someone.
Right, you can still sue them.
Exactly. It simply inserts a new administrative hurdle. The legislature realized the courts were just drowning in a backlog of cases, so they altered the machinery of justice to force people to try settling first.
So the ultimate destination is the exact same. The route is just heavily detoured.
That's a great way to put it.
But, altering the route or adding features raises a massive timing issue, what the source calls temporal application.
This is where it gets really tricky.
It really does. If a legislature changes the rules, does it only affect people who play the game tomorrow, or can it reach back in time and change the score for people who played yesterday?
Retrospective application.
Right. The textbook brings up the Supreme Court of India case, Narayan Namboodiripad v. State of Kerala from 1970. The government amended a land acquisition statute to alter compensation rates.
Right, for people whose land was being taken.
Yeah, and the court actually applied those new rates retrospectively to land disputes that were already in the middle of being fought in court.
They changed the rules mid-game.
Exactly. So if laws can suddenly apply retroactively like that, how do you or I ever protect ourselves against a system where the rules change after the fact?
Well, what's fascinating here is the incredibly delicate tightrope the judiciary has to walk to prevent outright tyranny.
Because it sounds tyrannical.
It does. But the baseline rule, like the default setting of the legal system, is a strong presumption against retroactivity. Courts assume an amendment only applies moving forward.
Unless they explicitly say otherwise.
Right. Unless lawmakers explicitly write, like in flashing neon letters, that they intended to look backward. In that Kerala land case, the judges had to forensically examine the legislative intent.
To figure out why they were changing it in the first place?
Exactly. Why was the compensation rate changed? The old rates were likely recognized as deeply unfair or just completely inadequate for the citizens losing their land.
Oh, I see. So by applying it backward, they're actually fixing an ongoing injustice, not just pulling the rug out from under people for fun.
Precisely. To build on that, the courts are always weighing that intent to fix an injustice against something called vested rights.
Vested rights.
Yeah, if you have a right that is already completely logged in, finalized, and sealed by a past transaction, courts are fiercely protective of that.
So they won't mess with a done deal.
Rarely. They will rarely let a retroactive amendment destroy a completed deal. They are looking for fairness in the transition, applying new rules only to cases that are still active and unresolved.
Okay, that makes more sense. But sometimes an update or an amendment just isn't going to cut it, right? The law's too broken, or society has moved so far past it that it just becomes a relic.
It needs to be deleted.
Exactly, it needs to be deleted. And the mechanics of deleting a law, what the source calls repeal, are surprisingly complex.
Very complex.
You'd think it's just a giant red stamp that says canceled, but there are actually a few different ways to kill a statute. Express, partial, and implied.
Express repeal is that giant red stamp.
Yeah.
It is the legislature being overt and unequivocal.
They just say it's dead.
Right. A prime example is when the Indian Parliament enacted the Unlawful Activities Prevention Act in 2004. Inside the text of that new law, they explicitly stated that the older Prevention of Terrorism Act of 2002, POTA, was completely revoked.
So the old law was formally executed by the new law, no ambiguity whatsoever.
Not at all.
And then partial repeal is more like a surgical strike. You don't blow up the entire penal code, you just carve out a problematic section.
Exactly.
We see this with the Information Technology Act of 2000. It came along and selectively repealed very specific defamation provisions buried inside the massive Indian Penal Code.
Purely to create a new, modern framework for online defamation.
Right, while the rest of the penal code survived totally untouched.
But then we enter the much murkier territory of implied repeal.
This one blew my mind.
It's a headache for everyone involved.
Yeah.
This happens when the legislature passes a new law that completely contradicts an older law, but they never actually bothered to formally repeal the old one.
Just sloppy drafting.
Pretty much. The classic precedent from the textbook is a House of Lords decision from 1875, Taylor v. Taylor.
2 statutes sitting on the books.
Yeah, 2 statutes regulating the exact same subject matter, but pointing in entirely opposite directions. The newer statute essentially acted as a silent assassin.
See, here's where it gets really interesting to me. Because you're describing a scenario where a law can be functionally dead, but nobody sent out a memo.
Nobody sent a memo.
Doesn't that mean we could be walking around right now completely unaware that the laws we are trying to follow have been secretly overridden? That sounds like a recipe for total legal chaos.
The potential for chaos is massive,
Yeah.
which is exactly why judges deeply despise implied repeal.
I bet.
They operate under a heavy presumption against it. A judge's job is not to clean up the legislature's sloppy drafting,
Right.
So when a judge is faced with 2 conflicting laws, they will attempt a mechanism called harmonious construction. They will bend the text, stretch the definitions, and look for any conceivable interpretation that allows both laws to coexist.
They basically force the 2 laws into a shotgun marriage.
Essentially, yeah. They might say, well, perhaps the old law applies to wholesale transactions and the new law applies to retail, even if it takes some serious interpretive gymnastics to get there.
Just to avoid saying one is dead.
Exactly. A judge will only declare an implied repeal as an absolute last resort, like when the conflict is so violently irreconcilable that enforcing both would basically break the universe. The intention to override has to be undeniable.
Okay, so whether a law is explicitly executed by a new act, surgically removed, or silently assassinated by contradiction, the ultimate result is that it dies.
It's gone.
Which brings us back to the scenario we started with. What actually happens to the people who are already tangled up in that law when it gets deleted?
To understand the sheer magnitude of a repeal, we have to look at Section 6 of the General Clauses Act of 1897.
Okay.
This lays out the catastrophic default effect of killing a statute. When an act is repealed, it isn't just retired to a dusty archive somewhere. Legally speaking, it is completely obliterated.
Obliterated?
Yeah. The formal doctrine states that it is treated as if it had never been enacted in the first place, except for transactions that are already entirely in the past and closed.
It's literally wiping the hard drive clean.
Exactly like that.
So if we look at real-world examples, say someone is charged under a state prohibition act or under that terrorism act we mentioned, POTA.
Okay.
The police arrest them, they are indicted, the trial is just crawling through the court system, and suddenly the legislature repeals the act. Section 6 kicks in, and the entire prosecution just evaporates.
It evaporates completely. The Supreme Court has been very rigid about this in cases like State of UP vs. Jagmander Das in 1954 and later in Gosraj Singh.
Just poof, gone.
The courts ruled that you cannot commence a new prosecution, nor can you continue a pending prosecution under a dead act.
Oh.
The moment the act is wiped from the books, the legal authority to punish someone under it vanishes. Enforcing it would amount to enforcing a ghost.
See, I have to push back on this a little bit because it sounds like a massive loophole.
How so?
Well, you commit a serious crime, you get caught dead to rights, but your defense attorney just files motion after motion to delay the trial.
Stalling tactics.
Yeah. They drag it out for years until the political winds shift, the legislature repeals the law, and you get off completely free. How is that justice?
I get why it feels that way. But if we connect this to the bigger picture, the philosophical foundation actually reveals a deep societal logic.
Okay, I'm listening.
Think about the underlying reason a legislature chooses to repeal a criminal law. It represents a collective shift in morality.
Society changes its mind.
Right. By deleting the law, society is formally declaring that this specific behavior should no longer be considered a crime at all.
Like repealing prohibition.
Exactly.
We realized making alcohol illegal caused way more societal damage than it prevented, so the moral judgment changed.
That's the perfect parallel. The moral imperative to punish the behavior evaporates along with the law. If society collectively no longer views the act as a punishable offense, expending taxpayer money and state power to lock someone in a cage for doing it 2 years ago serves no rational purpose.
It just becomes punitive for the sake of being punitive.
Exactly.
But wait, what if the government is just updating a law? Say they want to replace an old environmental regulation with a slightly different one, but they still absolutely want to penalize the factories that dumped toxic waste last year under the old rules. How do they prevent those pending cases from just vanishing into thin air?
They have to use a highly specific drafting tool called a savings and transitional provision.
A savings clause.
Yes. A competent legislature will embed a savings clause inside the new repealing act. It acts as an anchor. It explicitly states, hey, we are obliterating the old law, however, any investigations, legal proceedings, or penalties that were already set in motion are safe.
So it artificially keeps the ghost of the old law alive.
Just long enough to process the people already caught in the system.
It's like a life raft for the prosecution.
It is.
But if the drafters get sloppy and forget to include that savings clause, the ship sinks and takes all the pending trials down with it.
Down to the bottom of the ocean.
Wow. Okay, we've spent a lot of time on laws moving chronologically, how they evolve over time and how they die over time.
Right.
But the textbook also digs into spatial geometry. What happens when two laws exist at the exact same time, governing the exact same issue, and they violently clash?
Yeah.
This brings us to the brutal hierarchy of parent legislation versus subordinate legislation.
This hierarchy is truly the backbone of the modern administrative state. So, parent legislation is the primary law, passed directly by the elected legislature.
Yeah.
Your parliament, your Congress, your state assemblies.
The big guys.
Right. But those bodies are slow. They are highly politicized, and frankly, they lack the technical expertise to manage the minutia of modern life. They can't possibly govern every tiny detail.
So they outsource the busy work.
They delegate their lawmaking power downward. They create subordinate legislation.
Which takes 5 distinct forms depending on who is holding the pen, according to the source.
That's right.
You have colonial legislation, which is mostly a historical artifact of kings making laws for specific territories. But the modern ones are fascinating.
Very much so.
You have judicial legislation, where the Supreme Court gets to write the operational rules for all the lower courts. Executive legislation is when massive government departments draft regulations for their own industries.
Like environmental or labor boards.
Yeah. Then autonomous legislation gives independent bodies, like the railways or central banks, the power to make binding rules for their highly specialized networks. And finally, municipal legislation, where city councils draft local bylaws.
And looking closely at why those exist is crucial. Like, a city council needs to draft municipal zoning laws because the national parliament doesn't know where a commercial district should end in a specific neighborhood.
They don't know the local streets.
Exactly. The railways need autonomous rulemaking power because a politician shouldn't be dictating the engineering safety tolerances for train tracks.
Leave that to the engineers.
Right. Delegation's a functional necessity. But, and this is a massive but, all of those subordinate rules are bound by the principle of supremacy.
The parent always wins.
Always. Central legislation overrides state legislation. State law crushes municipal bylaws. If an agency uses its delegated power to write a rule that conflicts with the Parent Act, it commits a fatal error. It becomes ultra vires.
Beyond its power.
Beyond its power.
I like to picture this as a massive corporate hierarchy. The parent legislation is the CEO. The subordinate legislation is a middle manager.
I love this analogy.
Thanks. So, the CEO issues a company-wide mandate. Everyone gets Fridays off. A week later, a middle manager sends out a departmental memo saying, in the accounting department, you must be at your desk on Fridays.
A direct conflict.
Yeah. That memo is ultra vires. The middle manager doesn't have the authority to overrule the CEO, and the moment the clash is discovered, the memo is shredded.
That structural dynamic plays out in courtrooms constantly. But judges, much like a good corporate HR department, will try to mediate first.
Really?
Yeah, they use that doctrine of interpretation and harmony we talked about. Before destroying the middle manager's rule, a judge will see if it can be read in a way that doesn't violate the Parent Act.
It's like trying to find a loophole in the memo.
Exactly. Maybe the subordinate rule simply meant, you must be available by phone on Fridays in an emergency. But if it's a direct, unapologetic contradiction, the subordinate rule is struck down as void.
Let's look at how that actually plays out when the gavel comes down. There are incredible historical cases in the reading where these agencies just completely overstepped their boundaries and got smacked down by the courts.
It's really famous ones.
Yeah, going all the way back to 1875, there's R.V. Prince. The parent statute, the primary law passed by the legislature, established the age of consent for marriage at 14.
Which was the standard at the time.
Right. But an overzealous subordinate authority drafted a regulation banning the sale of intoxicating liquor to anyone under 16.
And the legal mechanism the court used to strike that down is crucial. The Court of Queen's Bench didn't invalidate the liquor rule just because they disliked it.
Right, it wasn't about the alcohol itself.
No. They invalidated it because the subordinate authority effectively tried to rewrite the legal age thresholds established by the parent legislature.
They changed the definition of adulthood.
Exactly. The parent said adulthood, in a legal sense for marriage, begins at 14. The subordinate agency didn't have the jurisdictional authority to unilaterally push a legal age barrier higher. It was a blatant power grab, and the court erased it.
A more modern structural power grab happened in India in 1972 with the Delhi Transport Undertaking versus BBL Hadjuri case.
Oh, the termination case.
Yeah. This one is entirely about the power to terminate employees. The Parent Act was crystal clear. No employee could be dismissed by anyone lower in rank than the general manager.
The GM was the absolute floor for firing authority.
And yet, the subordinate rules framed under that exact same act contained a provision allowing the general manager to delegate his firing power down to the assistant general manager.
It's an administrative attempt to bypass a statutory bottleneck.
Just passing the buck. The GM didn't want to deal with every single termination, so he tried to outsource it.
Which makes logistical sense, sure, but makes zero legal sense. The Supreme Court dismantled it instantly. The legal logic was simple. A subordinate rule cannot be used to rewrite a fundamental safeguard built into the Parent Act.
If Parliament wanted the assistant GM to have that power, they would have written it that way.
Exactly. The subordinate rule was violently ultra vires.
And, it doesn't always have to be a direct contradiction of a rule. Sometimes ultra vires happens just because an agency gets lazy and skips a step.
Procedural violations.
Yes. The Banwarol versus State of Bihar case from 1961 perfectly illustrates this. The Parent Act was the Mines Act of 1952, and it contained a mandatory procedural hurdle. The central government was legally required to consult the mining board before drafting any new regulations.
They couldn't just guess. They had to ask the experts.
Right, but the government rushed ahead and framed an entirely new set of rules without ever convening or consulting the board.
Just completely ignore the requirement.
Yeah. And when it went to the Supreme Court, the judges didn't even look at whether the new rules were good or bad. They declared them void from inception purely on procedural grounds.
The power to make the rules was conditional on the consultation. By skipping the condition, they operated entirely outside their jurisdiction.
When you lay it all out like this, it seems like these departments and agencies are just constantly overstepping, constantly pushing the boundaries until a court slaps them down.
It does seem that way.
If it leads to all these messy, drawn-out ultra-vires battles, why do legislatures keep giving this power away?
Because the alternative is total governmental paralysis.
Really? Total paralysis.
Absolutely. If you strip away subordinate legislation, every single detail of modern society has to be debated on the floor of the national legislature.
Oh, that sounds like a nightmare.
Think about the Motor Vehicles Act. Imagine the entire national government halting its debate on foreign policy because they need to pass a parent act determining the exact timing sequence of a traffic light in a specific city.
Nothing would ever get done.
The system would collapse under its own weight. We accept the friction of agencies occasionally overstepping because that delegated power is the engine that actually makes the state run.
So what does this all mean for you? Why does mapping out this incredibly intricate legal machinery actually matter to your daily life?
It's a fair question.
Because the rules governing your business operations, your property rights, and your personal freedoms are not carved into stone tablets. They are that mutating, highly reactive organism we talked about at the top of the show.
They are constantly in motion.
They're constantly being amended to graft on new features. They're being repealed to reflect massive shifts in societal morality. And they are constantly being challenged and struck down in turf wars between higher and lower authorities.
It's a very fluid system.
Exactly. Understanding this fluidity, knowing that the rules can be bent, updated, or outright annihilated, doesn't just make you well-informed. It makes you a much sharper citizen and a highly strategic professional. You stop seeing the law as a brick wall and you start seeing it as a complex system of levers and pulleys that you can actually navigate.
That is the perfect takeaway. The law is a living ecosystem. But before we close out, this raises an important question. Something a bit unsettling for everyone to mull over.
Oh.
Yeah, we've spent a lot of time discussing the dramatic ways that laws are killed off and deleted, but we haven't talked about zombie laws.
Okay, I'm hooked. What is a zombie law?
It's hidden in Section 24 of the General Clauses Act, which governs repeal and reenactment. It dictates that if a parent law is repealed, but then instantly reenacted without major modifications, say the legislature just wants to consolidate some chapters or update the title, something highly unnatural happens.
Like what?
All those subordinate rules, municipal bylaws, and executive orders that were born under the dead parent law, they don't die with it.
Wait, the parent law is obliterated, but the subordinate rules just detach and float around.
They do more than float. Section 24 magically preserves them and instantly attaches them to the new replacement parent law.
Are you serious?
They are legally deemed to have been issued under the new act, even though they were written years ago, for a statute that technically no longer exists.
That is wild. The parent dies, but its ghosts immediately possess the new host.
Precisely. So the next time you hear a politician proudly announce on the news that a controversial, outdated law has been completely repealed and replaced, take a very close look at the fine print.
Because the rules might still be there.
Ask yourself, are you still being quietly governed by the undead rules of the old regime?
What an incredibly eerie but brilliant point to end on. The law really is a living, mutating thing, and sometimes it refuses to stay in its grave. Keep questioning the rules around you, keep looking for those ghosts, and we will see you on the next deep dive.